Our next panel is Gaps in Companion Animal Legal Protection. My name is Megan Senatori, and I'm the Executive Director at the Center for Animal Law Studies at Lewis and Clark Law School. In this session, we'll explore gaps in the laws protecting companion animals. Our expert panelists will analyze these challenges across three specific contexts, which I will share with you when I introduce them. Most importantly, we hope that you'll leave this panel with tangible strategies to advocate for companion animals who slip through the cracks, including exploring innovative legal remedies, leveraging the vital collaboration between lawyers and veterinarians, and utilizing advocacy and litigation to shift societal norms. And now I'd like to briefly introduce my co-panelists. In the middle, here we have Daniel Kolde, who is an attorney in private practice at Kolde Law in St. Louis, Missouri. He will be talking about the use of excessive force by law enforcement against companion dogs. Next to Dan is Conley Wouters, who's an assistant professor of law at the University of Illinois Chicago School of Law, and he'll be sharing insight on an area that you may not have considered, the use of dogs in security work. And then finally, right next to me, is Dr. Alba Michelle Gonzalez, who is a veterinarian and the founder and medical director of Rascal Unit, which is a mobile veterinary practice providing affordable care for animals in Ohio. Dr. Gonzalez will be sharing insights from her work on a recent Ohio Supreme Court victory for stray or community animals. And I'd encourage you to visit the website for the full bios of our speakers who all share wonderful expertise with us today. So with that, we are going to get started with Dan.
Thank you, Megan, and I want to thank ALDF for this opportunity. This is, one of the oldest legal advocacy organizations in the country, and it's my honor to be here with you all today. I also want to thank ALDF because with their support, the two local law schools in St. Louis University and Washington University, both now offer classes in animal law. I'm kind of partial to SLUs because that one's mine, but WashU's good too. So the earlier panel mentioned training of police officers and encounters with companion animals, mostly dogs. When that training either doesn't take or is not conducted, I am the guy that you call because I'm going to sue them for it. We have a term for this. It's called puppycide. It's been around since 2012. I think a journalist named Radley Balco with the Washington Post first coined this. So yes, this is puppycide when the police come and shoot your dog. The picture there is a dog named Teddy. Teddy was owned by my client, Nicholas Hunter, Sturgeon, Missouri. Maybe some of you have seen the newspaper articles. Officer Hunter decided one day to shoot this 13-pound blind and deaf Shih Tzu. And hopefully, if I get through everything, at the end we can talk about that case. So I have a lot of slides, I have a lot of information, 18 minutes, explain Fourth Amendment, explain qualified immunity, 30 years of case law, and your three cases, so go. So let's get started here. The shooting of family pets has been described as an epidemic. And according to a 2011 DOJ report, they estimated 10,000 dogs per year are killed by police officers. An organization that was active about 8-10 years ago, they don't seem to be very active anymore, put that number at 5,000. The ASPCA estimates that 50% or more of all officer shootings involve a dog. Low estimate, Wired magazine has reported 300 to 500 per year. I personally think that is extremely low. And the source for that is a gentleman named Merritt Clifton, who some of you may be familiar with. If you're not, ask Lady Van Cavage. She'll tell you all about this guy. If you look here, between 1963 and 2012, no police officers were killed by dogs. 2 by bees, I'm guessing anaphylaxis. 1 by a cow, and I'd really love to know that story. My guess would be a car accident. If we go back before that, between 1880 and the 1940s, 5 officers died from dog bites. 3 from secondary infections, back before we had good antibiotics, and 2 from rabies. But since 1963, now that we have antibiotics and rabies vaccines, 0 police officers have been killed by dogs. And it's not just about dogs. This is a case in Iowa. So out of the Iowa Des Moines Register, an officer was at the home on a keep the peace warrant. His wife and husband were splitting up. Dog comes running out. Officer goes to shoot the dog, misses, slips on the ice, and his second shot hits and kills the woman in front of her 3-year-old daughter. This is out of Texas. Officer responds to a loose dog call. You see the dog running there. Right behind the dog, what you don't see is the dog owner. The officer misses the dog. The shot jumps up, ricochets up, and kills the dog owner. This is probably the worst one of all. And I hope these guys all got fired. So this was Yana. Yana was killed by DeKalb County Police in 2015. Police responded to a home burglary alarm going off. First problem was they went to the wrong address. The homeowner, whose burglar alarm was not going off, according to the newspaper, was sitting there watching the baseball game. It's Georgia, so I'm guessing he's sitting there watching the Braves game with his dog. Here's a commotion in the yard, goes to the back door, opens the door. Yana jumps out, starts barking. The 2 cops covering the back of the house open fire. Seriously injure the homeowner, kill Yana the dog. At the same time, a 3rd officer had made entry through the front door and was running towards the back of the house. And in the gunfire, they shot and seriously injured their fellow officer. So wrong house, dead dog, seriously injured civilian, and friendly fire, seriously injured fellow officer. And so this is why training, I think, is really important. It's just not about the dogs. People get killed as well. Sometimes they do good things. This is an officer out of Texas. Dog comes running out of a house, clamps down in his arm. He does not shoot the officer, or shoot the dog. Instead, he de-escalates and gets an award and gets a lot of press for it because it's so exceptional when they don't shoot. That becomes the news stories these days. But again, this is why with legislation, for mandated training is important. 6 states currently mandate officer training. We need a lot more. So a little bit of brief history on the killing of pets. Again, it happens a lot, right? Officers are killing a lot of pets. Pets are not killing a lot of officers. The first case I could find of a suit against a law enforcement officer for the killing of a pet was 1993 out of Minnesota. This was state law claims. Suchek owned a German Shepherd. German Shepherd gets loose. Some neighbors call to report a wolf in the neighborhood. 3 officers show up. They see the German Shepherd, don't think very hard about if that's a wolf or a German Shepherd. 17 shots, killing the German Shepherd, who most certainly was not a wolf. For federal cases, the big year is 1994. And if you ever litigate these cases, you're going to see this in every opinion you read, and you're going to want to put these in every brief that you write. 1994, Lesher v. Reed, an 8th Circuit case, was the first circuit to recognize that pets are constitutional effects, a fancy way of saying property for purposes of the 4th Amendment. It was not a dog shooting case. It was a dispute between a canine officer from Little Rock and his department. His sergeant and a couple of his fellow officers came and seized his dog. He filed a lawsuit, and the 8th Circuit said, of course, dogs are property, and as property, they are constitutional effects. About 6 months later, we have probably the first dog shooting case out of California, Fuller v. Vines. And Fuller v. Vines, citing to Lesher v. Reed, establishes that pets are constitutional effects. So if a government official kills your pet, that is a violation of your client's 4th Amendment constitutional rights. About 2003, these things start to become very prevalent in the media. This is a Tennessee case. The puppy there is named Patton. Officers mistook a family driving on vacation for a car that was suspected in armed robbery, pull the car over, get the family homeowners out. Dog comes following, and officer unloads on the dog with a shotgun, killing him instantly. At the time, we're also starting to get body cameras, so this thing is on body camera all over the news. One tip out there is if you ever hear of one of these and you hear there is body camera, every state has open records laws. Look at your state open records laws and try to get your hands on these things and share them everywhere. So big public outcry. The family ends up on the Today Show. The Tennessee governor demands an apology, and lawsuits filed settles for about $77,500. The next big case we have is Hells Angels v. City of San Jose. If you can think of a worse client to have as a plaintiff civil rights lawyer, a Hells Angels with a police department serving a search warrant for evidence of a first-degree murder. It's not your ideal client. But during the process, they shot and killed 3 Rottweilers on the various properties, 3 Rottweilers belonging to Hells Angels. So big dogs belonging to scary people. Summary judgment to the officers was denied, and the case went forward, ended up settling for a total of $1.8 million. It was not all about the dogs. There were some other constitutional violations in there. But we have this very important phrase. In addition to Lesher and Fuller, this is the third case you want to make sure appears in any pleading you file. We have recognized that dogs are more than just personal effects. The emotional attachment to a family's dog is not comparable to possessory interest in furniture. What's really important about this is if you try to file claims for the death of a pet under state law, a lot of times all you're going to get is fair market value and not emotional distress. Hells Angels and this one statement has started a line of precedent in case law where you can recover. Those are your damages in one of these cases. The emotional distress, and there's no question about your entitlement to it like there is in state law claims. This is another one. I'm not going to... another innocent homeowner, SWAT raid. Che Calvo was the mayor of Barron Mar, Maryland. Gets caught up, innocent victim of drug trafficking. The police go to, it's not technically the wrong house, but he had nothing to do with the trafficking. FedEx driver was leaving packages on the porches where he didn't think homeowners were normally present. One day his accomplice doesn't pick up the package. The police are watching and they send in a SWAT team to the mayor's house in this rather affluent area and shoot and kill both of his dogs. He also filed a federal lawsuit and undisclosed amount on that one, but again, lots of media attention. This is Megan's case, that's Bubba. Velo v. Air, and that was the Seventh Circuit case from 2008. In 2008, the court in Velo, there was a question of, we'll talk about qualified immunity and what that means, but the officers were basically saying they were entitled to qualified immunity. Because it was not well established within that circuit that the shooting of a family pet was a violation of someone's constitutional rights. And the court said every circuit that has considered this issue has held the killing of a companion dog constitutes a seizure within the meaning of the Fourth Amendment. At the end here, in slides I probably won't show you, I've included a representative case from every circuit. So 2008, it was probably about half the circuits had recognized this principle. We are now up to, I think since April, every circuit now has appellate law on this point. 2011, the DOJ Cops Office publishes a report, The Problem of Dog-Related Incidents and Encounters. You might recognize one of the names up there. It's my friend Leedy. Was one of the co-authors of this. And it was one of the first extensive studies and recommendations, including training, on the killing of family pets. 2012, famous article by Radley Balco. This is where the term puppycide gets introduced. 2016, a documentary comes out. It is a powerful documentary. It is very difficult to watch, called Of Dogs and Men. And there's a couple of the directors there sitting on that panel, and you might recognize the other gentleman in the black and white photo that was ALDF's director, and my friend Chris Green was one of the executive producers of this. And this is about the time I started getting into these with my first cases. So let's talk a little bit about the nuts and bolts of one of these cases. And I'm going to go kind of quick here because you want to hear about the cases more than about boring law professor, repeating your Con Law 1 lecture from years ago. So dogs are currently considered property everywhere in the United States, every jurisdiction. The book up there that I have is kind of important. It's called The Law of Property. It was published in 1900. That is the first American legal treatise on animal law. So as a movement, we do have roots going back to the 1900s. I mean, it's not the cutting edge animal rights stuff that we think of today, but the fact that it exists, I think, matters for something. So when you analyze these cases, this is the Fourth Amendment, right? We all know the Fourth Amendment, unreasonable searches and seizures and warrants. Again, pets are constitutional effects. They cannot be unreasonably seized, without a warrant or some exception to the warrants requirement. I have never seen, and I never expect to see, a case where a judge signs a warrant authorizing a police officer to go shoot somebody's dog in their backyard, but I've seen stranger things out of federal courts, judges, I guess, these days. So when you sue, you can't just file a lawsuit saying, oh, you violated the Fourth Amendment. You have to have, we all know the phrase private right of action. Next, 42 U.S.C. 1983 creates this private right of action. It was passed in the 1870s. It was originally known as the Ku Klux Klan Act of 1871. At that time, only federal officials could use this law. It was mostly for Reconstruction and Southern officials who refused to acknowledge the 14th Amendment. So it gave the feds authority to go into states for those purposes. In the 1960s, a case called Monroe v. Pape, the Supreme Court realized you could use 1983 to bring, private individuals could use 1983 to bring suits for monetary damages against police officers and government individuals. When you have one of these, I mean, it's real kind of simple. A seizure is a meaningful interference with possessory interests in property. Pets are effects. Warrantless seizures are per se unreasonable. And the officer can't act in a way that's more intrusive than necessary. So he's got to use the least amount of force possible. If they fail to do that, then, well, you can make an argument. And what I've put here is a lot of stuff that an old lawyer gave to me. So I'm not going to go through all that in detail because, again, it's not a law school lecture. If you ever have one of these cases, that is a checklist that this lawyer gave to me, and I stuck it in here so you guys could have it. So if anybody calls and says, please shot my dog, you pull this up and you say, oh, there's all that checklist stuff we didn't talk about. But here's the one thing I really want to talk about, qualified immunity. Think of qualified immunity as every horror movie monster that you can imagine coming to eat you. This is a way, qualified immunity is a way that government officials can kill your case before you ever get to a jury. And it protects officials from lawsuits, discretionary acts. Two-pronged test: was the law clearly established, and did the officer violate that established right? It's not that simple, because the second one looks like one of those summary judgment fact questions. When I first did these, I was like, oh, I'm never, qualified immunity does not scare me. Now qualified immunity scares the hell out of me, now that I've lost two of them on qualified immunity. A couple phrases here with qualified immunity. First, you'll see it gives officers a lot of deference. It says, well, officers are in tense, stressful situations. That's true. And if it is tense, stressful, and it's bona fide legitimate, and there's somebody's fear for being hurt or killed by a dog, then okay, I mean, it's probably not unconstitutional. The thing is, it's kind of become a mantra these days, that everything is, oh, I just was afraid for my life, even if it's a 13-pound Shih Tzu. The other thing is it allows officers to act reasonably unreasonable, which means that if their actions were unreasonable, but they made a mistake of law or fact about the situation, then they can get away with it on qualified immunity because it was reasonably unreasonable. I lost one on that exact phrase. When you think about it, for the rest of the known universe, that's called a fact dispute, and summary judgment's not being granted on that. Were you in true fear? Was the dog really that aggressive? Those are fact questions. But private parties do not get qualified immunity, and you're going to have to deal with that if you ever take one of these cases. So, tale of three dogs. These are the three cases that I've handled. That's Kaya, and Teddy, and Sierra. Kaya was shot by St. Louis County. We ended up settling with them, survived qualified immunity, settled with them for $750,000. Teddy, the defendants on that one have filed a notice of settlement. It's not been formalized, so I can't really talk very much about it. But that case is coming to an end. We filed summary judgment, but there was no rulings on those. And the last was Sierra, who from Kansas City, who was shot. We did lose that one on qualified immunity. Took it up on appeal, and the Eighth Circuit denied us again. So here's Teddy's story. An officer gets called. A neighbor finds a little dog, 13-pound Shih Tzu, wander in her backyard. Doesn't know who the owner is. Calls dispatch, which is kind of the county clearinghouse for all non-emergency calls. Well, in the city of Sturgeon, they do not have animal control. The police officers are animal control. So they send Officer Woodson out. So Woodson gets there, spends about 3 minutes trying to ineffectually capture Teddy with a catch pole. Teddy's roaming this kind of field area, is running away from the cop, is basically escaping every time this cop gets the catch pole around him. This officer later would say, well, he thought he was reasonably unreasonable in believing that Teddy was so seriously injured and suffering that humane euthanasia was appropriate. After being run around, but chasing this dog around this field for 3 minutes, he's like, oh, well, he was so seriously injured, it was humane. So let me finish up here. My time is almost up, so let me finish up with Teddy. If you want to hear the other two stories, find me during the break, I'll be happy. So that's the catch pole. He admitted he didn't know how to use one of these things. It's a wire and a pole. All you do is pull the string and it tightens the loop. And yes, the matter's going to be solved, so that one does not, that's not going to matter anymore. So, but I think my time is up, and I have other people that I do not want to, and I will be like I am with my law school class. I'll be running down the hall still saying, wait a minute, the lecture's not done yet. So any questions? We can talk about the other two cases. If you want, find me later. But thank you, everyone, for your time.
Now, go ahead. I'll stay here to introduce our next speaker. First of all, thank you, Dan, for that very comprehensive overview and for taking these cases, because they seem like they should not be hard. They are surprisingly challenging. So thank you for taking cases like this. Conley will be our next speaker, and Conley and I were talking about, we'd love to see a show of hands. How many of you have seen the canine security dog since you've been in Chicago? Has anybody been? Some? Okay. All right.
Great. All right. Then, yeah, if you haven't yet, you are very, sorry, I'm just setting a timer because I have the same problem as a law professor, or a stopwatch. Yeah. So if you haven't seen these dogs, if you were to take the CTA, that is our public transit, there's a very good chance you will. So I'm going to talk to you about private security dogs in general, as well as these specific dogs here in Chicago. And by that, I simply just mean dogs that are working for private security agencies, as opposed to, say, police departments or any sort of public entity. So I'll do this by just giving you really quick background, then giving you an overview of state and federal law, which I can kind of do really quickly because there basically is almost none. Then I'll talk about the CTA as sort of an example or a case study of these laws, more like what they look like in practice, and I'll wrap up by making some recommendations or general thoughts. I also want to say this is like a work in progress. This is research that I'm working on for scholarship, so I'm especially open and interested to any thoughts or questions, critiques you have. Whoops. I think I'm missing a slide there, but that's okay. Wait, I'm missing some slides. I mean, I can do it without the slides, but okay. I'm just going to have to talk, and you'll just imagine the visual aids. I'll try to be as descriptive as possible. All right, so imagine there's a big quote, and at the bottom it says, Senator Debbie Halverson, Illinois State Legislature, 2007, and she's on the floor, and she's talking about how there was this dog in a metro station or a CTA station, and it was bomb sniffing, or was just walking around, and she says, but we didn't know who this dog was. We had no idea what his job was, who he worked for, and so as a result of that, Illinois passed a law that essentially was meant to answer that question. Who is responsible for these dogs, and who is ensuring their welfare and safety, right? That question, who are these dogs, is still the status quo, I believe, for private security dogs all over, and also particularly in Chicago. So in Chicago, as I said, there's a lot of dogs on our public transit, right? They look like this. They have muzzles on 24/7. By the way, that's how you can tell that they're private security dogs and not police dogs, because police dogs don't have muzzles on all the time you see them. But none of us know this. We're all riding the train, and I had a slide with like all these examples. There's a Chicago Tribune headline that says, Democratic National Convention to bring in increased police presence on the CTA. And then it has a photo, and that photo is not of a police officer, it's of a private security officer with his private security dog. So there is this confusion. You hear it over and over again. Who are these dogs, basically? And that's what I set out to answer here, and I'm still trying to answer it. And in order to sort of get at that question, the question of which laws are there that might, A, answer the original question, but also B, protect these dogs' interests, I'll just tell you one thing about the industry in general, the private security industry in general, for the sake of time. It's really, really big, and it's almost not regulated at all. That's a little bit of a hyperbole, but not much of a hyperbole. So for example, in South Carolina, you need like 4 hours of training to become a private security officer and 4 more if you're going to be an armed private security officer. There are 8 or 9 states where you don't need to be trained at all. The leading expert in this area in private security law calls it, are they still up there? Our screen went blank. I mean, it doesn't really matter because, okay. The leading expert in this industry calls it a, quote, hodgepodge, an extreme variety, right, in terms of, do you have to get licensed as a private security guard? Does the firm have to get licensed with the state as a private security firm? Extreme hodgepodge, but the general, where it ends up overall, not many regulations. So you all see where this is going. If I move to laws that relate to these dogs specifically, so by that I mean, are there any licensing or training requirements for the canine handlers, right? Do you have to be trained to know how to work with these dogs? Are there any welfare requirements under state law that apply specifically to private security dogs? And the answer is a little tiny bit. Let's start with the first category. Okay, this is going to be difficult. I don't know where the slides are. They're in there, but they're not. It's going to be a little tricky to explain because, there they are. There they are. Okay, I saw them in the other view. But then when there they are. Wonderful. Okay. Thank you. Thank you. Whoever did, I could not have fixed that on my own. See, if this were my classes, my students would know. You'd just be stuck with no slides. So there's the Chicago Tribune. There is what I was talking about with the industry in general. You see those headlines. We have about 1.2 million security guards in the US as of 2023. That's doubled in the last 20 or so years. So here is the overview of state regulation of canine security firms. Illinois is the only one to have meaningful requirements specifically related to the humane treatment of these dogs. There are a couple other states we're still looking into that sort of mention it, but Illinois has a pretty comprehensive framework. So that's what I'm going to talk to you about right now. I'll use Illinois as an example. And this sort of breaks down into 2 different statutes. So I'll start with the Private Security Act. There's a much longer name than that includes like locksmiths and alarm agents. So I just call it the Private Security Act. This is implemented and enforced by the Illinois Department of Financial and Professional Regulation. So in other words, the agency that oversees businesses, right? Under the regulations of this statute, canine handlers do have to be licensed. They need about 100+ hours of training to work with the dogs. The firms themselves have to get a separate license as a canine security firm. And the IDFPR actually has like pretty broad, it's all discretionary, but it is very broad disciplinary authority. It can impose monetary sanctions if it thinks a firm, any firm, including these firms, is not complying with the laws. It can revoke licenses, deny renewals, et cetera. So I'm going to come back to that. But that's why I mentioned the sunset date, because I think this law could be a pretty important tool for protecting these dogs. And I don't want it to go away, and I hope that date gets pushed back. On the other side, the Illinois Animal Welfare Act is one of two key pieces of state legislation we have for animal protection in Illinois. And under the regulations of the Illinois AWA, there is a section called guard dogs. So these are the dogs that we're talking about that you saw in the photo. They're referred to as guard dogs or security dogs. And there are very specific requirements related to the treatment of these dogs. And again, they're pretty good, at least on paper. So the Department of Agriculture, who enforces the statute, they can go in, and if they see a dog on duty, like the dog you saw on the first slide, and they decide she looks malnourished or ill or injured, they can just take her to a vet, right, and make sure she's okay. There are other things that would sound familiar to you all, like humane transport requirements, humane housing requirements for where the dogs live and train. So that is the Illinois Animal Welfare Act. I know I'm jumping around a bit, but when I get to the end, hopefully it'll make sense why I'm doing that. I'm now going to move real quickly to federal law. And what I want to talk to you about here is a report done by the Government Accountability Office in 2022. It's a really interesting and thorough report. And what they did was they undertook to study every federal working dog program that exists. And the reason they did it is because they had been getting complaints and concerns about the potential treatment of the dogs. So there are about 5,100 dogs total being used in federal working dog program. The vast majority of these, by the way, and this is true of dogs, I'm talking about the CTA as well, are either detection dogs, bomb sniffing dogs, or just patrol dogs, which is really mostly what you're going to see here in Chicago. So interestingly, in this report, they split it up. Half of it, they looked at, okay, which are the programs managed by the federal government itself, and which of these programs are managed by third-party contractors, right? Contracting out, hiring a security firm, just as the CTA has done. So I'm focused on the latter. That's what you're seeing up on the screen. GAO identifies 18 key welfare issues. They go through each of the contracts in all of these working dog programs, and they ask, does the contract address each of these issues? So that's all the issues. I have some highlights here on my notes, which of course I'm just ignoring. But I can tell you that less than half of these contracts they found do not mention things like welfare, right? Whether evaluation of the animal's welfare or welfare training. They don't mention abuse or neglect or exercise. None of the programs they studied addressed all 18 of the issues, and there was one that addressed none of them. So what did they do as a result? They made some recommendations. They said, here's what you should do. You should address all of these 18 issues, and you got to do it. Put it in your contract documents that you have, the contract with the security firm, and then report it to Congress. That became this federal statute that was enacted last year, and it's really just that. Take the recommendations from the GAO report, put them into your security canine firm contracts, and then submit your report to Congress by just a couple months ago. Last time I checked, we're pretty good at everyone meeting the deadline except for the Department of Defense, which is unfortunate because I'm sure they use a lot of dogs. So is this great? It's not the best because as you see there, so far as I can tell, there's no actual, there's no regulations or enforcement mechanisms. It seems to me just like oversight from Congress and perhaps withholding funding if they're not satisfied. But I do think it's a good model because to me it kind of takes seriously the question that I started with, which is who are these dogs? They undertook to find all of them and get basic information as to who they were, what they're doing, what their jobs are, and how they're being treated. They did, by the way, say in there that like, there's one more agency that we didn't hear about until after we completed the study, which I don't blame them for, but that just sort of gives you a snapshot of like how difficult this is, right? Or sort of how under the radar these dogs can be. Okay, so switching back. I appreciate you jumping around with me. I'm going back to Chicago here. Real short snippet of CTA's long history with canine security contractors. In July of 2019, the Chicago Tribune publishes an expose, and it basically shows that the security firm they were using at the time had violated the regulations I was telling you about earlier with respect to the licensing, the training. CTA, there's fallout. Obviously, CTA says, okay, we're done. We're not going to use security canines anymore. And they said in their press release, by the way, that they didn't say anything about this, so far as I remember. They said they're not actually that safe. People are less safe when we use the dogs, so we're just going to go to unarmed teams of 2 security guards patrolling without animals. They must have changed course at some point because less than 3 years later, they hire a new firm, you see there, for 18 months. That contract expires. They award them another contract in January of this year for like $90 million. So this is, if you're a Cook County taxpayer, it's a lot of money, right? And this all started because I've been a CTA rider for a very long time. I've been in and out of Chicago for like almost 20 years. And this started because, like many people, I was on the train to work one day and I saw something that upset me. So I submitted my first FOIA request in August 2024. I submitted a bunch of them up until, I don't know, over the summer. And the main things I was looking for was A, the contract, which took me forever to get, but I did get it. And B, I asked for essentially like complaints from the public that related to security dogs or the security officers in any way, shape, or form. So some of what I found were they gave me over 6 complaints over that 18-month period for end of 2024. Some of them were kind of silly. They were like, oh, they're just on their phones too much, the security guards. But a lot of them alleged pretty severe abuse of the dogs while on duty, kicking, punching, choking the dogs. And one alleged a dog was kicked repeatedly in the head while other officers stood around and laughed. And then I also tried to get records that would show whether or not or how CTA dealt with these complaints. Like, is there a process for investigating or resolving? They did give me responsive records to that, and I just focused on like the 4 or 5 most egregious allegations. And in every case, they just showed CTA's customer service department forwarding the complaint to another department in CTA, and that was the process. And then in the contract, I should say, what I have on the screen there says no records of CTA policies or contract provisions addressing canine welfare. I should have inserted the word meaningfully, because there are phrases that kind of like, like address this idea in passing, like contractor must ensure good nutrition or provide good nutrition, right, and hygiene or something. I tried to get records of what that actually meant or how they knew that was being that was happening, and I didn't really find anything. Okay, so what does all this mean? It means we have a problem, obviously, because Illinois is such an outlier in that we even have these laws in the first place. But if these allegations have any merit to them, then obviously the laws are not doing the job as they were intended to do. So I'm just going to wrap up here, and I tried to avoid going way too deep into the weeds on the law for everyone's sake, but I'm more than happy to talk about it more if there are questions. But I'll say, what could we do at the state level? We could just start with the GAO report, which again, I think is a really helpful model to start with the first question of what's going on here, and just do state versions of those types of studies. All the other stuff up there is going to look pretty familiar to you, just from like kind of a general accountability and transparency standpoint, right? Reporting requirements in terms of anything you could think of, like the dog's health, nutrition, any incidents, use of force. There's no use of force policy. No records that would catalog any instances. By the way, you might be wondering, very understandable question, which is like, what do they actually do with these dogs? Which a lot of people wonder. I haven't been able to find anything really that directly addresses that in the contract, but journalists have asked the CTA that, and they haven't given an answer. And then one journalist, a local journalist, asked an actual security guard, and the security guard told him, well, we can't take their muzzles off, or they can't really do anything unless it's a quote unquote life or death situation. So from the records I found, they basically, when they see someone they think is violating the law, they forward that information to Chicago Police Department. So you can draw your own conclusions from that, but it seems like the dogs may just be there to try to scare people. And it may not be working because the people are actually really worried about the dogs, not scared of the dogs. Okay, so all that other stuff, I mean, what it essentially says there is, let's try to do what they did, A, in the GAO report, and B, in Illinois. And you might be thinking to yourselves, well, you just said Illinois was a complete failure in enforcing the laws. And that's true, I did, but I really think it's not so much because people don't care or people don't want to, including the agencies that have authority to do so. I think it's just, they're just kind of sitting there and no one's really aware of them. From the legal research I've done on it, I can't really find any history in terms of administrative decisions. I've done some FOIAs asking for inspections or enforcement actions against these firms or against public entities contracting with them. I haven't found any. I'll say one thing and then I'll skip to the, am I okay, Daniel? Okay, all right, then I'll say a couple of things on this slide. I have public outreach and education there, and you all know what that means generally, but I was actually thinking about, I should have been more specific here. What I'm actually thinking about is like, the CTA should tell us what's going on and who these dogs are, right? Because the CTA is very good at marketing. I follow them on Instagram, and they post about all their special events, and they post about their leadership riding the trains and meeting, Chicago commuters. It's all great, I'm sure it's genuine. I think they do really want to connect with the public and their ridership. But so far as I can tell, and I haven't looked at every single Instagram post, so I could be missing something here. But as far as I can tell, they don't mention the dogs, aside from the fact when they put out the press release of awarding the new contract. So I would like to see just the kind of the principle of, if we're going to fund public agencies who then contract out these services, right? It's one thing to hold the firms accountable, that's great. But we're funding these security dogs, and I think we need to hold our governments accountable for the treatment of those dogs. One way to do that is just to say you have to address that in the contracts. I'll end by saying specifically lawyers. How can we help? But this first one is actually, it's not just lawyers. Law students can do this, anyone can do this. Make a complaint to the agency that regulates businesses, right? I was talking about how the IDFPR has a lot of authority. They also, I didn't even mention some of it. They can go to a court and petition, they appoint like a prosecutor once they get a complaint. I think that's the language they use in the statute, in the regulations. And they can go to a court and ask for injunctive relief, basically like shut this business down until we figure out what's going on, right? So as a lawyer especially, you could submit like a very detailed complaint. Litigation, FOIA lawsuits, and these three litigations, they all assume, right, that the firm is contracting with a public entity. FOIA lawsuits, where necessary, it did become necessary in my case. Taxpayer actions and mandamus, this is more of like an idea. I'm not an expert on this, so I'd love to hear from anyone who is, but the basic principle, again, being the same thing, like if we're funding this, if we're funding these working dog programs in part, then let's hold our state government or local governments accountable for the treatment of those dogs. And that might be one way to do it in litigation, right? If you see something in the contract that it doesn't seem like one or the other party is complying with. Lastly, legislative efforts kind of speaks for itself. I do think there would be a lot of sympathy here from state legislators. So I'm done. Upshot is, I really do believe there's a lot of room for like collaboration on this from lawyers, non-lawyers, all of us. So I'd love to hear your thoughts and come find me afterwards. And look for those dogs if you ride the train this weekend. Thank you so much. I appreciate it. Real quick, I almost forgot, and Daniel reminded me. I also really want to thank the ALDF because we also got an animal law course going at UIC Law thanks to their support. So thank you.
Awesome. Thank you, Conley, and especially raising awareness about such an issue that people don't consider, and we'll see the dogs and now think of all your work. And with that, Dr. G, to end us on a positive note and some success in the past year.
Thank you, Megan, and thank you to LDF, and especially thank you for all my instructors at Lewis and Clark, because you guys made it so that I could participate in things like this. So thank you so much. So why am I here? I'm a veterinarian, and I do forensics, and I help with animal cruelty and neglect cases, but I also help with a lot of different things. And that was the importance behind the animal law degree, was kind of like everything comes around full circle. So I'm going to be talking about State versus Kyles, which was how the impact of one decision impacted all animals in the state of Ohio. So, maybe? Do I have to point? There, yeah. All right. So a little bit of background on what State versus Kyles was. Alonzo Kyles was charged under Ohio Animal Cruelty Law 959-131 for an incident with an 8-month-old kitten. So this is a kitten that was loose inside of an apartment complex in the laundry room. So Kyles goes to the laundry room, sees this 10-month-old kitten, and allegedly says that he was scared and terrified of this cat, so he didn't know what to do with it. So to get it out of his way, he doused it in bleach. Thankfully, the kitten was fine. The kitten was taken to a veterinarian who noted the injury secondary to like the caustic substance and such, but the kitten was able to make a full recovery, was adopted. Kyles was found guilty of felony animal cruelty and pleasantly surprised that he was sentenced to 9 months under that statute. In Ohio, the people can be sentenced anywhere between 3 months to a maximum of 12 months. So for us, 9 months was kind of big because there are people that commit egregious, assault against animals and don't get anywhere near that much. So that was really good. However, Kyle's attorney appealed the decision because the cat was unkept. So what does this mean? This is one of the things that from going to school I learned about intent, right? So say what you mean what you say. I remember one of the cases that was something about a law involving dog fighting and then how cockfighting was not part of the law because it was not the intent of the law, right? So it's kind of among us the same thing. The law in Ohio says that a companion animal is any animal that is kept inside a residential dwelling and any dog or cat regardless of where it's kept, right? So regardless of where it's kept. So that sounds pretty straightforward. So the problem with that, just twice there, the problem with that is that the way that the appeals court read it is that in order for a dog or cat to be protected, it must be kept. So the appeals court said, yep, it's reversed. This is not felony animal cruelty because this cat was not kept, so it's not a companion animal. So then this is taken all the way to the Supreme Court to see if we can reverse this decision. So they requested the reversal of the appellate court, and everything was based on the intent of the law. And they requested amicus briefs. The prosecutors at the Supreme Court level requested amicus briefs in support of the prosecution. I'm a board member with a group in Ohio called Ohio Animal Advocates, which is primarily attorneys. And then I started in that group as a veterinarian, just giving advice, and then I'm a board member. So they came to me and they're like, gee, you want to be part of this amicus brief? And I'm like, yes. What's an amicus brief, right? Because I'm not an attorney, so. But they explained it, and it was pretty interesting, like a really cool way to, be part of the Supreme Court. So this is just a copy of the initial page of the one that we submitted, so that it has everybody that participated from our group. And there were multiple of these briefs that were sent. So my part, we had 3 arguments, and my part was argument 1. And it's basically about how the appellate court erred in their, in the interpretation of the word kept. I'm a veterinarian, I'm not an attorney, so everything to me is kind of like, simplistic, like let's break this down and see what it's about. So one of the biggest key points was that the word kept was inclusive, not exclusive. So prior to this, the way that the statute was read did not include pet stores. So then they said, regardless of where they're kept, to include pet stores, to include anywhere that an animal may be, so not just a residential dwelling. So that was, the first part of my argument. Then the second part is, as we keep talking about, animals are property, so a lot of these laws are property laws. Well, 959-13 and 959-131 are not property laws, they're animal protection laws. So if it's not a property law, who cares if it's owned or not? Ownership is irrelevant. From a veterinary standpoint, to me, if you bring me your personal cat that you love and lives inside and sleeps in your bed, or you bring me a cat in a trap, to me it's a cat, right? It's the same thing. There's no difference, intrinsic difference between a community cat and a cat that is owned. Therefore, again, it doesn't make sense to separate both animals just because of one is kept and one is not kept. Now, devil's advocate. Let's play your game and said that it must be kept. Well, Mr. Kyles became the keeper of that cat because he assumed possession of it when he decided to act upon it. So, hey, guess what? It's your cat now. The cat was in overall good condition. So some form of care was taken of it. And it's potentially like the people in the apartment building maybe feeding it, grooming it, doing whatever, but to a certain extent, it's kept. And the third part is we cannot assume that a cat that is outdoor is not kept just because we don't know who the owner is. There are plenty of people that have indoor-outdoor cats. Not every indoor-outdoor cat is microchipped. Cats don't like tags. So we cannot make that assumption just based on the fact that we don't know where the cat lives. The answer from the defense, they brought up case law saying, oh, no, this woman had these birds, and she had to prove that the birds were kept in order to protect them. Right, because it's not a dog or a cat. And that actually, his point on his end was really a point on the other side. It's dogs and cats are regardless of where they are kept. The revision of the statute was also intended to advance human interest by protecting animals. So we have a lot of people that don't care about animals. It's just a cat, who cares? Right, but we are doing these things to protect the community. It acknowledges the link between animal cruelty and interpersonal violence. So you may not care that he hurt this cat, but maybe he hurts a person. In this particular case, I want you to meet Mr. Alonso Kyles, who beat his girlfriend's 12-year-old with a bat, a belt, and a pole, and was found guilty of child abuse. And this was in 2017, way before he abused this cat. So there is a link. Somebody that's gonna hurt an animal is gonna hurt a human, and vice versa. And this is the intent of that law. I have a podcast called The Animal Welfare Junction, so anybody that's interested in finding more about this, I did an interview with the prosecutors for the Supreme Court, Tasha Forshoni and Sarah Hutnick, and we discussed everything that they went through in order to prepare, how everything was presented, and then, just how those amicus brief actually did create an impact and help them in presenting their case. Finally, just the impact of this decision. So why was this decision important? Well, the guy on the left, his name is John Bai, and he was in Butler County, Ohio, and he was found guilty. He chased a cat inside of an apartment building, put the cat in a bag, and slammed the bag against the ground, causing fractures to this cat, and then threw the bag with the cat in a trash can. So they they were going to prosecute, and then the Supreme Court case was happening. So his defense attorney said, no, you cannot charge him under felony animal cruelty because this cat was unkept. And Alonzo Kyle's case, State versus Kyle, says that this cat is not kept. So thankfully, they put everything on hold until the Kyle's case was done. And once it was done, they charged him with felony animal cruelty, and he was convicted of such. The second case is Rhonda Murphy, and she was in, I don't know, she wasn't in Cuyahoga, but anyway, she's in Cincinnati. And she was a hoarder, like a rescue sanctuary type hoarder, and they got 90 animals alive, and there were 30 dead animals in her house. So they charged her under felony animal cruelty laws, and she was sentenced to 54 months in prison. Well, she appealed the sentencing, saying that it was too extreme, and the judge in that appeal said, no, because State versus Kyle says that all animals matter, and because all animals matter, this sentence is adequate based on the crime that was committed. So, it was one simple decision that has so far been important in two big cases, and hopefully is going to lead the way to better animal protections of all dogs and cats, not just those that are owned. And I speak very fast, so I just flew through all that. So thank you very much. There's my information.
Thank you. Thank you, Dr. G, and all of you for such wonderful presentations. Starting with you, Dr. G, it is, I think, clear to all of the lawyers what the benefit is of having veterinarians involved in these cases. Is there a benefit to veterinarians in getting involved in legal matters, and if so, what is it?
Yeah, I think it's really important because when I started working in veterinary medicine, right, like I want to help animals. And I can help one animal in my exam room, or I can learn about the law and I can learn about advocacy and help multiple animals. So in this case with this cat, like I could have helped that cat by providing medical care, but instead by helping in the legal background of it, I can help all dogs and cats.
Any advice to veterinarians who want to get involved in legal matters from your own work doing it?
Yeah, absolutely. So, I mean, obviously Lewis and Clark, but yeah, just learn, getting in contact with advocacy groups, getting in contact with prosecutors, with attorneys, and just learning about it. And even with forensics, if they're not comfortable or they don't have the means, the resources to get legal advice, coming around with the with forensic people, because just the same as I say, I know things as a veterinarian that you may not know, but you know things as an attorney that I don't know. So it takes everybody coming together to put a complete package.
Great, thank you so much. Dan, I want to ask you, you gave an example of several cases, 3 at the end there, and we didn't get through all of them, but for what are your biggest pieces of advice for lawyers who want to take these kind of cases regarding the use of force against companion dogs?
So the first piece of advice, and this is just general advice for any animal law type case, and the first animal lawyer I ever dealt with, she worked for ALDF, told me always use the non-human animal's name in your pleadings and in your arguments, and make sure your clients do the same thing. So, for example, the one case that we was very successful, the $750,000 settlement for the shooting of Kaya. If you look at the judge's summary judgment order, which I put in my materials, she used Kaya's name 69 times. Never once said the dog, never once said it. So it was always Kaya or she. The case that I lost, the judge always said the dog and it. So, if we're going to do this, if we're going to change the law, we have to start changing the mindset of judges. And I think one way to do that is get them to see our non-human clients as beings with names, as individuals. The other thing is you need an expert in these cases. It's going to cost money. I've had people call me about these cases. Their clients can't afford it. They can't afford it. With the qualified immunity, the reasonably unreasonable, you need another police officer to come in. And fortunately, I have one that was a 22-year Jacksonville, Florida police officer, retired with lieutenant, has testified about 20, 30 of these cases. He's incredible. I say that it's really his case, and I'm just kind of the guy with the license that's making sure that he gets into the courtroom. And the other thing I would say is if you ever come across one of these cases or know anyone that does, call one of us who have done one of these cases. Like when I had my first case, I called Megan, and she talked to me for 30, 40 minutes. I called Karen Evans, who handled the Hells Angels case. She talked to me for an hour. It's a small community of us that have really done these cases. I can maybe think of 15, 20. So call one of us. In the materials, I put all my pleadings out there. If you call me and say, hey, Dan, can you help me with this? I'll send you the discovery I use. So it's a very collegial group. So always use the animal's name in any pleading, a dog shooting case, any type of case. Make sure you have your expert and call somebody who's done one of these cases.
Great tips. And I'm going to add one to Dan's about using the dog's name in the pleading. Don't use the dog's name and then say the dog, because you'll see a lot of people do that, Bubba the dog or Max the dog. We don't talk about humans that way. We wouldn't say Danielle the human. I'm looking at Danielle. So that's another way. You see people kind of doing both, and it tends to stick out and then kind of put down the fact that the case is about a dog. So I want to invite people to come up to go ahead and go to the microphones. I've got a question for you, Conley, first, but people who have questions, we'll go ahead and start to take those as well. But Conley, so your work is in a really interesting area that I know I hadn't really given a lot of thought to. Have you found that there is like a cultural disconnect between how we treat dogs in canine security work versus companion dogs? And if so, how does the work that you're doing, how do you envision that addressing it if it does?
Yeah, I have. I think it might be like a slightly different split, at least as I've seen it though, which is the difference between the private dogs and like public, like government managed working dog programs, particularly police and military. And I think it's just a question of visibility, right? And I think there are two reasons for this. Like, I always come back to this question that I have, that everyone in Chicago has, like, are those police dogs? I don't know. Like, on the slide, I also had a DM in response to an Instagram story, video of the dogs. And I'm like, I think those are police dogs, but I think they might actually not be police dogs. I think there are mainly two reasons for this. And I would say, by the way, I don't think there's a disconnect between how we treat them or how we want them to be treated, at least. It's just this knowledge gap. And I think the reason for this knowledge gap is, A, if you have a police department or military, right, like just by their very nature, they're not private entities. So there is at least potentially more transparency there, more information there, more visibility there. Secondly, because the security industry has like exploded basically since 9/11, we didn't really have them before, and so these security teams are proliferating so quickly, we might just assume that they're police dogs. That's my best guess.
You mentioned the example from the FOIA request, somebody who made a complaint with egregious abuse of a canine security dog. Are you seeing any enforcement happening, or have you not been able to determine that from your FOIA request?
I haven't been able to determine it, to figure it out from the FOIA request. I mean, obviously, I can really just look at, I haven't seen any enforcement from the IDFPR with the agency, or any similar agency, I should say, right? And I haven't seen any enforcement from the CTA or any even sort of like investigation into the complaints. And I should say, Dana was saying like, it's not just about the dogs. That's true here too. There were a lot of allegations of sexual harassment, verbal harassment, physical abuse of CTA riders as well. So yeah, none that I've found so far.
Great. Thank you all for those. We're going to go ahead and take questions. We can start over here on the right. Sarah?
Hi, Sarah Thompson, Right There.
Sarah, if you could speak up a little bit.
Yes, Sarah Thompson, Right There Law Group, Expand Animal Rights Now, and soon joining Lewis and Clark. Thank you guys for your presentation. I've seen yours, Conley, before, and I feel like it's expanding every time you've done it, so it's really exciting to see. My question actually is for Daniel. I have done one taser case that caused, you guys might have heard of it, it was Enzo in California, and it caused this dog to die, and it was animal control, and they just tasered this poor dog to death in the middle of the street while everyone was watching. It was horrible. We settled the case for $300,000 with the city of Lodi in California, but I was curious because I didn't experience a difference between that and the shooting cases with a gun, but I was curious if you have experienced a difference between those types of excessive force cases, and also I was curious if the Hells Angels case, have you used that in any other context beyond dog shooting because of it basically saying that, you know, animals are more than furniture, and I'm always looking to expand emotional distress damages and other types of tort cases. So kind of twofold question.
Okay. I've never seen a non-shooting case like the taser case. I'm not familiar with that one. There was one just within the last 6 months. It was a pretty egregious case. I believe it was the Plowright case out of Florida, where one officer tasered the dog. The dog goes down, and then the other officer shoots the dog after the dog has been tasered on the ground. I mean, frankly, it doesn't make any, I mean, it's still a use of force analysis. It doesn't matter if the force is a gun or a taser. The question is still, is it excessive? Was the dog posing an imminent threat? And, you know, if an officer would taser a dog, and the first volt, was sufficient and kept repeating, yes, that could be, excessive. So it's the force. It's not the type of force necessarily. It's the amount of force, and was it reasonable under the circumstances? With Hells Angels, this is, under the Fourth Amendment. These are federal 1983. If you were going to try to make an argument to a court for greater than fair market value in a non-official, like a private citizen case, I certainly would be throwing in Hells Angels and all the other federal courts and saying, wait a minute, look, all the other federal courts have recognized this. What's the problem with our state here? I could see that being not really binding because they are different sources of law, but it would be something I would throw in a case like that as for some persuasive value.
Thank you.
Thank you. Yes, please go ahead.
Hi, this is Eric Nicholson with Colorado Law. I had a question.
If I could have you speak up just a little bit,
Yeah,
it's
sure.
harder for us to hear up here than you would.
Got it. Yeah, so I'm Eric Nicholson with Colorado Law, and I had a question for Conley. Now, you talked an awful lot about who these dogs are and kind of investigating what you can figure out about who these dogs are, but I'm personally really interested in who these dogs were. That includes things like where are they coming from? What kind of dogs are being selected for these private security firms? How old are they? Is there any kind of standardization? Are they coming from the same breeder? Are they coming from some nebulous black box where they just show up at the firm at some point? Have you found anything regarding where these dogs are coming from?
Yeah, a little bit. It's a great question. It's a really important question. A lot of them, so first of all, there are specialized breeders all over the world that breed security dogs, both for private firms and for the government, right? The ones that the federal government use are like crazy expensive. They're like super fancy, I don't know. They're in Holland or Belgium because you have the Malinois, the Shepherds and all that. Malinois, I don't know how to say that breed. But in terms of breeding as well, at least some of these firms also are breeders. So they breed their own dogs. They buy some dogs and they breed them. And by the way, maybe people have thought of this, does the federal AWA apply to these firms? I kept meaning to email Delciana Winders and see if I could ask her that question, and I forgot to. I think it doesn't because there's an exception for security dogs, but also this question of breeding could potentially bring them under the scope of the AWA. So yeah, that's all I've found so far. It's a really good question.
Thank you.
Thank you. Yes.
Hi, I'm Pete Paxton with Seed. I see a lot of confusion on commercial dog cases between law enforcement and the USDA. The biggest problem I have is I'll see a cruelty violation, clearly a violation of the state cruelty code, and the target is USDA licensed. And the most common thing is that the cops look at that and they say, they're USDA licensed, we're gonna kick it off to the USDA so that way they enforce the AWA without a clear understanding that whether that's done or not, they can still enforce the cruelty code. And so I'm wondering if as you're going through this and you're dealing with all of these different problems, right? And if you're talking about like Chicago Transit, and if you have third-party verification or maybe separate codes for handling these animals, is that something you encounter a lot where there's confusion between who's enforcing the law and does doing this, enforcing this one law, does that prevent another law, like the standard cruelty law, from being enforced?
Great, thank you. Great question. I don't know if.
Yeah, I mean, that's kind of been a problem. I mean, we can look back at the Silver Springs, the monkey case, State v. Taub, where the Maryland Supreme Court said that the things like the Animal Welfare Act trumped state cruelty law. Missouri, from where I'm at, has an express exception in our law from our cruelty law. They say if it's if the AWA might apply, then state cruelty laws don't apply at all. So I mean, yeah, there are some legal hurdles, and a lot of states are looking to say, well, no, that's the USDA's problem. That's the Fed's problem. We're not going to even deal with this.
Anything to add, Conley?
Yeah, so I have found a version of this. So I think it was on the slide, but I forgot to mention it. Those two statutes I was talking about, right? The business statute and the state anti-cruelty statute. These security firms have to essentially register or get licensed under one or the other. Both statutes apply, but so what I think is happening is exactly what you're talking about. I don't know that it's so much confusion as like, well, you got them because they're licensed there, right? But both laws still apply. So it's the same thing. Like the most egregious example of this to me is the 28-hour law, where like there's like I don't even know how many agencies that could arguably be responsible there, right? So yes, it's either confusion or I think just an assumption that someone else is taking care of it.
Thank you.
Thank you. Yes, please.
Hi, I'm Deborah Bresch with Harvard Animal Law and Policy Programs. I have a question for Conley. Also about the dogs. And I don't want to oversimplify this problem. Obviously, this issue has long tentacles in many respects. But I just wonder in the search for allies, political allies, whether in this particular moment you have considered the historically, and I don't know if you discussed this at the beginning of your presentation, I wasn't here, but the historically authoritarian usage of these dogs. And whether that might get some purchase with state government, Governor Pritzker.
Yeah, absolutely. Thank you. That's a really good question. So the very little scholarship that has been done, right? There's a lot of scholarship on police dogs and various issues with police dogs, but the little scholarship that has been done on private security dogs, that is a huge concern in the private security law scholarship more generally, obviously, right? Is you're essentially just contracting out authoritarianism. So I think that would have purchase. I'll also say really quickly, it's complicated too, in Chicago at least. I'm just talking about this contract, because there are incentives for businesses. I won't remember the name of the program, but it's like a minority-owned businesses, or I think if they employ a certain amount of minorities, right? So like there are these competing interests. On the one hand, exactly what you're saying, but I also think, and this firm pays pretty well, to their credit. They really pay pretty well. So I think they are like serving the community from a labor standpoint, but then yes, I think that is a pretty powerful argument. And wherever Michael Swistera is, he's written a great article about sort of the intersecting oppressions of this. Yeah.
Cool, thank you.
Thank you so much. We have time for one more question with the caveat to the panelists that the answer should be brief because I've been flashed the sign. So yes, please go ahead.
Hi, my name is Paulina. I'm a student at UIC Law. And my question is in regards to the shooting dog cases. So you mentioned that the 0 police officers were killed by dogs. Have you encountered the argument that then the shooting is working or something of that nature? And how would you think about it or counter that?
No, and I mean, that is just one statistic. There's also imminent threat. There could be possible serious injury. That's why when we do Fourth Amendment, we always talk about totality of the circumstances. Now, I mean, there are statistics out there, and if my expert were here, he would give a much better answer. But, he is a police officer, former animal control. He's now a PhD in veterinary forensics. It is very uncommon for a healthy adult who's, not elderly, not a child, just a healthy adult, especially police officers who should be at least somewhat physically fit, to be killed by a dog, a single dog. It's especially household pets. It's probably not gonna happen. Now, multiple dogs, serious physical injury, of course, it's possible. And then we look at the totality of the circumstances, and that's where the reasonableness calculation comes in. I guess, my big criticism and concern with the courts would be they're too quick to apply this qualified immunity and give credence to that, well, I was, reasonably unreasonable in my fear for attack or whatever. But yeah, I mean, there's still, that statistic, doesn't mean that it's not dangerous to be a police officer and that dogs can't pose danger, but it's that it's not the extreme danger that they sometimes try to paint it out to be in seeking qualified immunity.
Thank you.
Thank you. All right, Conley, Dan, Dr. Gonzalez, thank you so much for helping us consider this topic for the good questions.